it's me again, your BSA student named Jenevive Comaingking. So yeah, first of all, before we start, I'm gonna remind you to take your vitamins. Yeah, take sentence the vitamins. You know, it's COVID and we really need to boost our immune system. So we need to, drink our vitamin C. So like, it's my, karon pa dyan ko kabalik o vlog after how many months na busy ko sa online class, yeah. And so karon I'm back with vlogging, and what we're gonna do right now is very aligned to what I did, diba? I take my vitamins. What I'm gonna do today is we're gonna have a law jog vlog. So basically, you guys know that I really love jogging, right? And since the pandemic started, I wanna jog, and it made me like nasikli jud ko kay na wala kay exercise. So yeah, I went back to jogging around November, and this is my first time filming myself while go jog, and I'm gonna do it while doing a law review. So, is that even possible? Yes, of course, I'm a BSA student and I can all the things which are very impossible. Charot. So, yeah. By the way, we're gonna use the book of Attorney Tingog ang Manok. Bala na siya. Attorney Andrex D. Domingo. So, I borrowed this from my friend in USJR. Hi, Rex. Thank you for letting me borrow this one. So, this is what I used for our revised corp code topic. Kaya I'm really having I'm really having a hard time finding a book ito para maka-advanced study ko, kaya the revised corp code is somewhat lisod jud siya, guys, and lisod yung sabot. So yeah, I really nangita jud kog book para makasabot ko. So yeah, this is what I use to review topics before our session with Attorney Fernandez para makasabot dayon ko, and what I encode na lang sa akong laptop during discussions are katong mga ipang-share ni attorney for additional knowledge. So yeah, let's start with this law jog vlog. So yeah, hello guys. As what I have mentioned, I'm gonna do a jog vlog for today. So now I'm headed to Cebu Business Park where I usually do my jogs. And so why did I walk? So basically, Cebu Business Park is just a kilometer away from us. That's why I just walked as part of my, warm up. And later on, if we arrived in the park already, we're gonna do the full warm-up exercises. And of course, I brought with me my book. So this book is authored by Attorney Andrex D. Domingo CPA. The title is Business Laws and Regulations, Partnership, Revised Corporation, Cooperative Law, Laws, Principles, and Jurisprudence. So yeah, there's gamay lang tao karon, and it's so nice, COVID. Yeah. Ito mo makikita. So yeah, that was my warm up. So it's very short because I already did my walks, then I already did some stretching along the way. That's what I really do. So yeah, so how does this jog vlog work? So I usually have this favorite block here in Cebu Business Park. Then what I'm gonna plan to do, since I'm gonna talk about 25 articles in between breaks of my one block jog, I'm gonna cite one article. Will that be okay? And along the way, I'm gonna insert some clips of the explanation of those articles. Would that be okay? Yeah, so now let's head on to my favorite block here in Cebu Business Park. So one of the reasons why I love that block because wala kay shade tao, then it's COVID pa baya, and I want to avoid some people sa kay, you know, yeah. I feel like I need to say to you the reason why I'm doing this jog vlog. First of all, because in our law class we are assigned to discuss 25 articles in a very creative way, and since I love jogging and we are in a busy week since it's still finals, and I usually really do my jogging every day if time permits, then I thought, why shouldn't I just incorporate my law articles in my jog? So yeah, tabianan ako. I have this chika that today it's karon kay 4 p.m. pa siya, and I usually do my vlogs my jogs every 5 p.m. but current earlier lang kay wala naman may class, but earlier this morning we had this Rizal exam. Then I really got stressed because it was a 105 item exam. Then the time is just for 40 minutes, and sadly I failed. Yeah, I failed because failed because I didn't finish the exam because it was a 105 item exam. Then it's just only for 40 minutes. So I got really sad, so I decided to just do some jogging and relieve some stress. Yeah. Wait, I'm gonna walk na towards the block. Okay. To read one article now. So first, it's a limited partnership. Article 1843. A limited partnership is one formed by two or more persons under the provisions of the following article, having as members one or more general partners and one or more limited partners. The limited partners are as such shall not be bound by the obligations of the partnership. So now, what does this article talk about? So now, let's talk about Article 1843. This article defines limited partnership. The correct usage of the term confines it to the form of business association composed of one or more general partners and one or more special partners, the latter not being personally liable for the partnership debts. So, what are the characteristics of a limited partnership? First, a limited partnership is formed by compliance with the statutory requirements. Second, one or more general partners control the business and are personally liable to creditors. Third, one or more limited partners contribute to the capital and share in the profits but do not participate in the management of the business and are not personally liable for partnership obligations beyond their capital contributions. Fourth, the limited partners may ask for the return of their capital contributions under the conditions prescribed by law. And fifth, the partnership debts are paid out of the common fund and the individual properties of the general partners. So a limited partnership is thus composed of two classes of partners, the general and the limited. The liability of a limited partner is limited to the amount of money he has put into the partnership. This limited liability is the key characteristic of the limited partnership. It is an exception to the general rule that all partners, including industrial partners, are liable pro rata with all their property for partnership debts. Thus, a limited partner has the same type of liability as a stockholder in a corporation. So, what are the business reason and purpose of statutes authorizing formation of limited partnership? First, secure capital from others for one's business and still retain control. Second, share in profits of a business without risk of personal liability. Third, associate as partners with those having business skill. One jog for this block is di naman kasi tiring bitaw. Kinaanad na ko, but yeah. So now let's proceed to Article 1840. The contributions of a limited partner may be cash or property, but not services. Why not services? Wait, let me jog. So yeah, now Article 1845, which basically talks about limited partners contribution. So a limited partner or special partner is not allowed to contribute services. He can contribute only money or property, otherwise he shall be considered an industrial and general partner, in which case he shall not be exempted from personal liability. The law is not satisfied by the limited partner's contribution in promissory notes, checks, particularly if they are post-dated, or bonds, or by a contribution partly in cash or property and partly in notes or checks. However, a check may be treated as an actual payment in cash where the limited partner has money actually in the bank to his credit, and the check gives the general partner absolute and final control of the amount named therein. Thus, a certified check or a manager's check satisfies the law. A check which is credited to the general partner by his bank as cash has been held to be cash payment by the limited partner. The contribution of each limited partner must be paid before the formation of the limited partnership, although with respect to the additional contributions, they may be paid after the limited partnership has been formed. So yeah, next is Article 1846. The surname partner shall not appear in the partnership name unless, first, it is also the surname of the general partner to the second, prior to the time when the limited partner became such, the business has been carried on under a name in which his surname appeared. A limited partner whose surname appears in a partnership name contrary to the provisions of the first paragraph is liable as a general partner to partnership creditors who extend credit to the partnership without actual knowledge that he is not a general partner. The surname of a limited partner shall not appear in the partnership name. So what happens if... wait, let me explain. We are in Article 1846. So, the surname of a limited partner shall not appear in a partnership name unless it is also the surname of a general partner, or prior to the time when the limited partner became such, the business had been carried on under a name in which his surname appeared. So, what is the effect where surname of limited partner appears in partnership name? So, basically, the limited partner violating this article is liable as a general rule to partnership direct creditors without, however, the rights of a general partner. Of course, such limited partner shall not be liable as a general partner with respect to third persons with actual knowledge that he is only a limited partner. To take a rest for a while, have a water break. So yeah, Article 1847. If the certificate contains a false statement, one who suffers loss or reliance on such statement may hold liable any party to the certificate who knew the statement to be false. First, at the time he signed the certificate, or second, subsequently but within a sufficient time before the statement was relied upon to enable him to cancel or amend the certificate or to file a petition for its cancellation or amendment as provided in Article 1865. So yeah, that was Article 1847. Like I realized that what I'm doing is very long. Well, yeah, I'm gonna proceed to this one with my facial test. Hold your eyes. Yeah. So now I'm gonna talk about Article 1847. So liability for false statement and certificate. So what are the requisites? So basically, under this provision, any partner to the certificate containing a false statement is liable, provided the following requisites are present. He knew the statement to be false at the time he signed the certificate or subsequently, but having a sufficient time to cancel or amend it or file a petition for in cancellation or amendment, he failed to do so. Second, the person seeking to enforce liability has relied upon the false statement in transacting business with a partnership, and the person suffered loss as a result of reliance upon such false statement. So basically, Article 1847 does not say that the guilty partner shall be liable as general partner. The liability imposed by Article 1847 is merely a statutory penalty and does not make the limited partner a general partner for all purposes, even as the third person. So for example, a limited partner appeared as a general partner in the certificate. If Article 1847 is applicable, he cannot raise the defense that he is merely a limited partner to escape personal liability to innocent third persons in case the other general partners are insolvent. For example, the contribution of A, limited partner, is erroneously stated in the certificate as 15,000 instead of 10,000. If Article 1847 is applicable, he may be made liable to innocent third persons for the difference of 5,000 pesos. So, in what I have stated the examples that I have stated. A is not liable and is a limited partner with respect to his co-partners with knowledge of the falsity. So my view now is like two buildings. I'm in between two buildings. So yeah. Article 1849. After the formation of a limited partnership, additional limited partners may be admitted upon filing an amendment to the original certificate in accordance with the requirements of Article 1865. So yeah guys, that was very nice. The view is very nice. Oh, yeah. So now we're gonna talk about Article 1849, admission of limited partners. Additional limited partners. So after a limited partnership has been formed, additional limited partners may be admitted. So the law requires that there is proper amendment to the certificate, which must be signed and sworn to by all of the partners, including the new limited partners, and files in the Securities and Exchange Commission pursuant to the requirements of Article 1865. The starting of a limited. My sweat is very nagtagal-tagal ako sweat, but it's okay. So yeah, so now we are in corporation now, and for section 1, title of the code. This code shall be known as the Revised Corporation Code of the Philippines. So now we are now in the Revised Corporation Code, and we're gonna start it with section 1, the title of the code. So sabotable rin ang article, but for more details, the present Revised Corporation Code, are mostly known as the RA number 11232, took effect on February 23, 2019. So, babuhay pa din siya. I realized that the view here in the bamboo is very nice, and it's very sad if I can show it to you. So now for section 2, corporation defined. A corporation is an artificial being created by a first operating law, having a rental succession in the powers, attributes, and properties expressly authorized by law or incidental to its existence. Yeah. Let me check. So now for section 2, corporation defined. So a corporation is the article itself defines what a corporation is. So a corporation is an artificial being. A corporation is a juridical entity vested with a legal personality, separate and distinct from those acting for on its behalf, and in general from the people comprising it. It has a personality separate and distinct from the persons composing it, as well as from any other legal entity to which it may be related. It is a basic principle in corporation law that a corporation has a personality separate and distinct from the officers or members who compose it. Not every stockholder or officer can bind the corporation, considering the existence of a corporate entity separate from those who compose it. So, what are the characteristics of a corporation? First is that it is an artificial being. It is created by operation of law. It has the right of succession. It has the powers, attributes, and properties expressly authorized by law or incidental to its existence. Guys, I realized that the book is very heavy, so yeah. Section 3, classes of corporations. Corporations formed or organized under the scope of maybe stock or not stock corporations. Stock corporations are those which have capital stock divided into shares and are authorized to distribute to the holders of such shares dividends or allotments to the surplus profits on the basis of the shares held. All other corporations are non-stock corporations. So yeah, yun else. And then yeah. We are now in section 3, classes of corporations. So basically there are two, stock corporation and the non-stock corporation. So a stock corporation, these are corporations which have a capital stock divided into shares and are authorized to distribute to the holders of such shares dividends or allotments of the surplus profits on the basis of the shares held are stock corporations. So for non-stock corporation, a non-stock corporation is one where no part of its income is distributable as dividends to its members, trustees, or officers, provided that any profit which a non-stock corporation may obtain as an incidental to its operations shall, whenever necessary or proper, be used for the furtherance of the purpose or purposes for which the corporation was organized. Yeah, it was very exhausting. So now section 5. Corporators and incorporators, stockholders and members. Corporators are those who compose a corporation, whether as stockholders or shareholders in a stock corporation or as members in a non-stock corporation. Incorporators are those stockholders or members mentioned in the articles of incorporation as originally forming and composing the corporation and who are signatories thereof. So now we are now down to section 5. So basically it talks about corporators and incorporators, stockholders, and members. So for this discussion, I'm gonna tell you the components of a corporation. First, the corporators, those who compose a corporation, whether as stockholders or as members. The incorporators are the stockholders or members mentioned in the articles of incorporation as originally forming and composing the corporation and who are signatories thereof. The stockholders are the owners of shares of stock in a stock corporation. For the members are the corporators of a non-stock corporation. The board of directors or board of trustees. The board of directors is the governing body in a stock corporation, while the board of trustees is the governing body in a non-stock corporation. For the corporate officers, so the president who shall be a director, a treasurer who may or may not be a director, a secretary who shall be a resident and citizen of the Philippines, and such other officers as may be provided for in the bylaws. If the corporation is vested with public interest, the board shall also elect a compliance officer. So, subscriber. So, a subscriber is those persons who have agreed to take and pay for original and issued shares of a corporation formed or to be formed. Underwriter, this is a person who guarantees on a firm commitment and or declared best effort basis the distribution and sale of securities of any kind by another company. A person or entity, especially an investment banker, who guarantees the sale of a newly issued securities by purchasing all or part of the shares for resale to the public. A promoter, a founder or organizer of a corporation or business venture, and one who takes the entrepreneurial initiative in funding or organizing a business enterprise. So furthermore, a promoter is a person who brings about or cause to bring about the formation and organization of a corporation by first bringing together the incorporators or the persons interested in the enterprise, second procuring subscriptions or capital for the corporation, and third setting in motion the machinery which leads to the incorporation of the corporation itself. I realized that my face shield got lost while doing my jog. So yeah, so in VM, I'm gonna proceed to section 7, founder shares. Founder shares may be given certain rights and privileges not enjoyed by the owners of other stocks. Where the exclusive right to vote and be voted for in the election of directors is granted, it must be for a limited period not to exceed 5 years from the date of incorporation, provided that such exclusive right shall not be allowed if its exercise will violate Commonwealth Act No. 108, otherwise known as the Anti-Dummy Law, Republic Act No. 7042, otherwise known as Foreign Investments Act of 1991, and other pertinent laws. So yeah guys, I'm gonna explain more about that. So now we are now at section 7, founder shares. So what are founder shares? So these are shares classified as such in the articles of incorporation, which may be given certain rights and privileges, example like dividend payments, not enjoyed by the owners of other stocks. So what are the limitations on founder shares? The exclusive right to vote and be voted for in the election of directors, if granted, it must be for a limited period not to exceed 5 years from the date of incorporation. I used my handkerchief to wipe my sweat because I don't want to look that haggard to you. So section 8, redeemable shares may be issued by the corporation when expressly provided in the articles of incorporation. They are shares which may be purchased by the corporation from the holders of such shares upon the expiration of a fixed period, regardless of the existence of unrestricted retained earnings in the books of the corporation, and upon such other terms and conditions stated in the articles of the corporation, and the certificate of stock representing the shares, subject to rules and regulations issued by the commission. Yeah, let's jog. And yeah, I'm really afraid because I lost my face shield. I hope I can just see it while jogging. Yeah. Are at section 8, redeemable shares. So what are redeemable shares? So they are shares that are usually preferred, which by their terms are redeemable at a fixed rate or at the option of either issuing corporation or the stockholder or both at a certain redemption price. So I took note some important parts in here, like a redemption by the corporation of its stock is in a sense a repurchase of it for cancellation. The present code allows redemption of shares even if there are no unrestricted retained earnings on the books of the corporation. This is a new provision which in effect qualifies the general rule that the corporation cannot purchase its own shares except out of current retained earnings. However, while redeemable shares may be redeemed regardless of the existence of unrestricted retained earnings, this is subject to the condition that the corporation has, after such redemption, assets in its books to cover debts and liabilities inclusive of capital stock. Redemption, therefore, may not be made where the corporation is insolvent, or if such redemption will cause insolvency or inability of the corporation to meet its debts as they mature. So, what are the limitations on redeemable shares? First, it must be expressly provided in the Articles of Incorporation. Second, the terms and conditions affecting said shares must be stated both in the Articles of Incorporation and in the Certificate of Stock. Third, it may be deprived of voting rights in the Articles of Incorporation, and redemption cannot be made if it will cause insolvency of the corporation, just like what I told you seconds ago. So, what are the kinds of redeemable shares? First, compulsory. The corporation is required to redeem the shares. And second, optional. The corporation is not mandated to redeem the shares. So the question, can redeemable shares be reissued? The answer of such is that redeemable shares, once redeemed, are retired unless reissuance is expressly allowed in the Articles of Incorporation. See people doing their jogs already. So it's 5 p.m. naman good. Then usually people go out at 5 p.m. to do their jogs. But gladly this block still gamay kay siyang tao. So I'm still safe here, I guess. I'm still safe here. But yeah, this is where I do my jogs man jud. Section I forgot what section naman. Section 9. Treasury shares are shares of stock which have been issued and fully paid for, but subsequently reacquired by the issuing corporation through purchase, redemption, donation, or some other lawful means. Such shares may again be disposed of for a reasonable price fixed by the board of directors. So yeah, gladly guys, I'm still the one supporting today. So yeah, I'm still fine. But when people get this block will get added, that's what is my favorite block. Now let's proceed to the treasury shares. Section 9, which covers treasury shares. So what are treasury shares? Treasury shares are shares of stock which have been issued and fully paid for, but subsequently reacquired by the issuing corporation by purchase, redemption, donation, or through some other lawful means. So what are the rights that are denied to the treasury shares? First, voting rights, and second, right to dividends. So I'd like to take note that treasury shares sold below par value are not watered stock, because watered stock contemplates an original issuance of shares. So I actually did a research about the watered stock in order to put more inputs in this section. And I found out that watered stocks are stocks issued for a consideration less than the par or issued price thereof, or in any other form other than cash valued in excess of its fair value. And take note that watered stock refers only to original issue of shares, but not to a subsequent transfer of such shares by the corporation. Thus, treasury shares may be sold for less than their par or issued value, for they have already been issued and paid for. G. Sa'yo na siya, no? Daling. Kaya wala mo sa ito. Yeah, okay. No tao. Section 10, number and qualifications of incorporators. Any person, partnership, association, or corporation, singly or jointly with others but not more than 15 in number, may organize a corporation for any lawful purpose or purposes, provided that natural persons who are licensed to practice a profession, and partnerships or associations organized for the purpose of practicing a profession shall not be allowed to organize as a corporation unless otherwise provided under special laws. Incorporators or natural persons must be of legal age. Each incorporator of a stock corporation must own or be a subscriber to at least one share of the capital stock. A
corporation with a single stockholder is considered a one-person corporation, as described in Title 13, Chapter 3 of this book.
So now let's proceed to Section 10, which covers number and qualifications of incorporators. Any person, partnership, association, or corporation, singly or jointly with others but not more than 15 in number, may organize a corporation for any lawful purpose or purposes. Natural persons who are licensed to practice a profession, and partnerships or associations organized for the purpose of practicing a profession shall not be allowed to organize a corporation unless otherwise provided under special laws. So now, this section introduces us to one-person corporation. So what basically is a one-person corporation? So it is basically a corporation with a single stockholder. Only a natural person, trust, or an estate may form a one-person corporation. Banks and quasi-banks, pre-need, trust, insurance, public and publicly listed companies, and non-chartered government-owned and controlled corporations may not incorporate as one-person corporations, provided further that a natural person who is licensed to exercise a profession may not organize as a one-person corporation for the purpose of exercising such profession, except as otherwise provided under special laws.
Section 11, Corporate Term. A corporation shall have perpetual existence unless its articles of incorporation provides otherwise. Corporations with certificates of incorporation issued prior to the effectivity of this code and which continue to exist shall have perpetual existence unless a corporation, upon a vote of its stockholders representing a maturity of its outstanding capital stock, notify the commission that it elects to retain its specific corporate term pursuant to its articles of incorporation, provided that any change in the corporate term under this section is without prejudice to the appraisal right of the dissenting stockholders in accordance with the provisions of this code. A corporate term for a specific period may be extended or shortened by amending the articles of incorporation, provided that no extension may be made earlier than 3 years prior to the original or subsequent expiry dates, unless there are justifiable reasons for an earlier extension as may be determined by the Commission, provided further that such extension of the corporate term shall take effect only on the day following the original or subsequent expiry date. A corporation whose term has expired may apply for a revival of its corporate existence, together with all the rights and privileges under its certificate of incorporation and subject to all of its duties, debts, and liabilities existing prior to its revival. Upon approval by the Commission, the corporation shall be deemed revived, and a certificate of revival of corporate existence shall be issued, giving it perpetual existence unless its application for revival provides otherwise. No application for revival of certificate of incorporation of banks, banking and quasi-banking institutions, pre-need insurance and trust companies, non-stock savings and loan associations, pawn shops, corporations engaged in money service businesses, and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency.
Now, let's proceed to Section 11, which covers corporate term. So the general rule is that a corporation shall have perpetual existence. So na ay forever. So corporation, sana all, no? The exception therefore is that if the articles of incorporation provides otherwise or if it provides a specific period. Take note that the corporate term for a specific period may be extended or shortened by amending the articles of incorporation. And a corporation for a specific period ceases to exist and is dissolved ipso facto upon the expiration of the period fixed in the original articles of incorporation in the absence of compliance with the legal requisites of extension of period. So I also included the revival of the corporate existence, which I find very essential in this section. So a corporation whose term has expired may apply for a revival of its corporate existence. The general rule is that upon approval by the Commission, the corporation shall be deemed revived and a certificate of revival of corporate existence shall be issued giving it perpetual existence. The exception: if its application for revival provides otherwise or provides for a specific period. So take note that the following corporations require the favorable recommendation of the appropriate government agency before the SEC will approve the application for revival of certificate of incorporation. First, banks. Second, banking and quasi-banking institutions. 3, pre-need. 4, insurance and trust companies. 5, non-stock savings and loan associations. 6, pawn shops. 7, corporations engaged in money service businesses. And 8, other financial intermediaries.
Guys, so mao to guys, sadly wa jud na ko nahuman ng 35 articles sa kuan sa pagjog kay plano ta na ako mobalik karon, then I realized it's a weekend, then I don't jog man good during weekends like TTHF ra dyan na Tuesday, Thursday, Friday kay basta weekend gali guys daghan jud kay nagtao dira sa Cebu Business Park and you know now we're trying to avoid crowded places. Yeah. So mao to. So ako plan na lang is to continue filming there somehow sa ako house. Ani jud ko kanaw sa ako ni study area. So now, yeah, let's proceed to section 12. So section 12, minimum capital stock not required of stock corporations. Stock corporations shall not be required to have a minimum capital stock except as otherwise specifically provided by special law. So watch out for the explanation.
So now, let's proceed to section 12, minimum capital stock not required of stock corporation. So the article is just so short. However, I'm gonna say to you the general rule and the exception of such in order to understand more the section. So the general rule is that there is no minimum authorized capital stock. However, the exception is if provided by special law.
Section 17. Corporate name. No corporate name shall be allowed by the Commission if it is not distinguishable from that already reserved or registered for the use of another corporation, or if such name is already protected by law or when its use is contrary to existing law rules and regulations. A name is not distinguishable even if it contains one or more of the following: the word corporation, company, incorporated, limited liability, or an abbreviation of one of such words, and punctuations, articles, injunctions, contractions, prepositions, abbreviations, different tenses, spacing, or number of the same word or phrase. The Commission, upon determination that the corporate name is not distinguishable from a name already reserved or registered for the use of another corporation, already protected by law, or contrary to law, regulations, and rules and regulations, may summarily order the corporation to immediately cease and desist from using such name and require the corporation to register a new one. Also cause the removal of all visible signages, marks, and advertisements, labels, prints, and other effects bearing such corporate name. Upon the approval of the new corporate name, the Commission shall issue a certificate of incorporation under the amended name. If the corporation fails to comply with the Commission's order, the Commission may hold the corporation and its responsible directors or officers in contempt and or hold them administratively, civilly, and or criminally liable under this code and other applicable laws, and or revoke the registration of the corporation.
We are at section 17 covering the corporate name. So the general rule is that each corporation must have a name by which it is to sue and be sued and do all legal acts. So yeah, a name is peculiarly important as necessary to the very existence of a corporation. Its name is one of its attributes, an element of its existence, and essential to the entity. The name of a corporation in this respect designates the corporation in the same manner as the name of an individual designates the person. And the right to use its corporate name is as much a part of the corporate franchise as any other privilege granted. So take note that no corporate name shall be allowed by the Commission if it is not distinguishable from that already reserved for the use of another corporation, or if such name is already protected by law, or when its use is contrary to existing law, rule, and regulations.
Yeah guys, now we are at section 18. Registration, incorporation, and commencement of corporate existence. A person or group of persons is arranged to incorporate shall submit the intended corporate name to the Commission for verification. If the Commission finds that the name is distinguishable from a name already reserved or registered for the use of another corporation not protected by law and is not contrary to law, rules, and regulations, the name shall be reserved in favor of the incorporators. The incorporators shall then submit their articles of incorporation and bylaws to the Commission. If the Commission finds that the submitted documents and information are fully compliant with the requirements of this code, other relevant laws, rules, and regulations, the Commission shall issue the certificate of incorporation. A private corporation organized under this code commences its corporate existence and juridical personality from the date the Commission issues the certificate of incorporation under its official seal, and thereupon the incorporators, stockholders, and members, and their successors shall constitute a body corporate under the name stated in the articles of incorporation for the period of time mentioned therein, unless said period is extended or the corporation is sooner dissolved in accordance with the law.
Now let's proceed to section 18, which covers registration, incorporation, and commencement of corporate existence. So we need to take note that it is the certificate of incorporation that gives juridical personality to our corporation and places it under the jurisdiction of the Securities and Exchange Commission. And a corporation commences its corporate existence and juridical personality and is deemed incorporated from the date the Securities and Exchange Commission issues certificate of incorporation under its official seal. So that's what section 18 is all about. Section 19,
De facto corporations. The due incorporation of any corporation claiming in good faith to be a corporation under this code and its right to exercise corporate powers shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a court proceeding. So now we're going to talk about Section 19, the de facto corporation. So the filing of articles of incorporation and the issuance of the certificate of incorporation are essential for the existence of a de facto corporation. The Supreme Court held that an organization not registered with the Securities and Exchange Commission cannot be considered a corporation in any concept, not even as corporation de facto. So what are the requirements before one can qualify as a de facto corporation? First is that the existence of a valid law under which it may be incorporated, an attempt in good faith to incorporate, and assumption of corporate powers. So there are two conflicting public interests under the de facto doctrine. So the de facto doctrine thus affects a compromise between two conflicting public interests. First is that the one opposed to unauthorized assumption of corporate privileges, and the other in favor of doing justice to the parties and of establishing a general assurance of security in business dealing with corporations. Generally, the de facto doctrine exists to protect the public dealing with supposed corporate entities, not to favor the defective or non-existent corporation.
We're at section 21, and my staff wants to say hi. Section 21.
Effect of non-use of corporate charter as continuous in operation. If a corporation does not formally organize to commence its business within 5 years from the date of its incorporation, its certificate of incorporation shall be deemed revoked as of the date following the end of the 5-year period. However, if a corporation has commenced its business but subsequently becomes inoperative for a period that is 5 consecutive years, the Commission may, after due notice and hearing, place the corporation under delinquent status. A delinquent corporation shall have a period of 2 years to resume operations and comply with all requirements that the Commission shall prescribe. Upon compliance with the corporation, the Commission shall issue an order lifting the delinquent status. Failure to comply with the requirements and resume operations within the period given to the Commission shall cause the revocation of the corporation's certificate of incorporation. The Commission shall give responsible notice to and coordinate with the appropriate regulatory agency prior to the suspension or revocation of the certificate of incorporation of companies under their special regulatory jurisdiction. Let's proceed to Section 21, Effects of Non-Use of Corporate Charter and Continuous in Operation. The first, failure to formally organize and commence its business within 5 years from the date of its incorporation. So, the certificate of incorporation shall be deemed revoked as of the day following the end of the 5-year period. Examples of acts constituting formal organization. First, adoption of bylaws and filing the same with the SEC. Election of board of directors or board of trustees, as well as the officers like the president, secretary, treasurer, and other officers as stated in its bylaws. Establishment of the principal office. Fourth, providing for the subscription and payment of its shares of stock. Other acts necessary to enable the corporation to construct business or accomplish the purpose for which it was created. So examples of acts constituting commencement of business. First, entering into contracts or negotiation for lease or sale of properties to be used as business or factory site. Making plans for and the construction of the factory. And third, taking steps to expedite the construction of the corporation's working equipment. For a second, continuous in operation for at least 5 consecutive years. So the SEC may, after due notice and hearing, place the corporation under delinquent status. So take note that a delinquent corporation shall have a period of 2 years to resume operations and comply with all requirements that the Commission shall prescribe. Upon compliance by the corporation, the Commission shall issue an order lifting the delinquent status. Failure to comply with the requirements and resume operations within the period given by the Commission shall cause the revocation of the corporation's certificate of incorporation.
We are now at section 46, and section 46 is very long, so I'm gonna let my staff read it to you. Is that even possible? Yes, of course. Section 46. Content of bylaws. A private corporation may provide the following in its bylaws: time, place, and manner of calling and conducting regular or special meetings of the directors or trustees. B. The time and manner of calling and conducting regular or special meetings and mode of notifying the stockholders or members thereof. C. The required quorum and meetings of stockholders or members and the manner of voting therein. D. The modes by which a stockholder, member, director, or trustee may attend meetings and cast their votes. E. The form for proxies of stockholders and members and the manner of voting them. F.
the directors or trustees' qualifications, duties, and responsibilities, the guidelines for setting the compensation of directors or trustees and officers, and the maximum number of other board representations that an independent director or trustee may have, which shall in no case be more than the number of prescribed by the commission. The time for holding the annual election of directors or trustees and the mode or manner of giving notice thereof. The manner of election or appointment and the term of office of all officers other than directors or trustees. I. The penalties for violation of the bylaws. J. In the case of stock corporations, the manner of issuing stock certificates. And K. Such other matters as may be necessary for the proper or convenient transaction of its corporate affairs for the promotion of good governance and anti-graft and corruption measures. An arbitration agreement may be provided in the bylaws pursuant to section 181 of this code. Wow, very good. Di ba makabasa siya? So now let's hear the explanation.
Section 46, the contents of bylaws. So bylaws is very important, and we need to get to know the contents of such. So first content is the time, place, and manner of calling and conducting regular or special meetings of the directors and trustees. The time and manner of calling and conducting regular or special meetings and mode of notifying the stockholders or members thereof. The required quorum in meetings of stockholders or members and the manner of voting therein. The modes by which a stockholder, member, director, or trustee may attend meetings and cast their votes. The form of proxies of stockholders and members and the manner of voting them. The directors or trustees' qualifications, duties, and responsibilities. The guidelines of setting the compensation of directors or trustees and officers and the maximum number of other board representations that an independent director or trustee may have, which shall in no case be more than the number prescribed by the Commission. The time for holding the annual election of directors or trustees and the mode of manner of giving notice thereof. The manner of elections or appointment and the term of office of all officers or then directors or trustees. The penalties for violation of the bylaws. In the case of stock corporations, the manner of issuing stock certificates and such other matters as may be necessary for the proper convenient transaction in its corporate affairs for the promotion and good governance and anti-graft and corruption measures. So take note that a private corporation may provide in its bylaws the modes by which a stockholder, member, director, or trustee may attend meetings and cast their votes. Also, we need to take note that a private corporation may provide in its bylaws the maximum number of other board representations that an independent director or trustee may have, which shall in no case be more than the number prescribed by the SEC. And we need to take note also that arbitration agreement may be provided in the bylaws.
So this is money ang anak sa akatong staff play na unggoy and karon mag section 47 na ta. Section 47, amendment to bylaws. A majority of the board of directors or trustees and owners, a majority of outstanding capital stock, or at least a majority of the members of the stock of a non-stock corporation at a regular or special meeting, duly called for the purpose may amend or repeal the bylaws or adopt new bylaws. The owners of 2/3 of the outstanding capital stock or 2/3 of the members in a non-stock corporation may delegate to the board of directors or trustees the power to amend or repeal the bylaws or adopt new bylaws, provided that any power delegated to the board of directors or trustees to amend or repeal the bylaws or adopt new bylaws shall be considered as revoked whenever stockholders owning or representing a majority of the outstanding capital stock or majority of the members shall so vote at a regular or special meeting. Whenever the bylaws are amended or new bylaws are adopted, the corporation shall file with the commission such amended or new bylaws and if applicable, the stockholders or members resolution authorizing the delegation of the power to amend and or adopt new bylaws duly certified under oath by the corporate secretary and the majority of the directors or trustees. The amended or new bylaws shall only be effective upon the issuance or the commission of a certification that the same is in accordance with the scope of other relevant laws.
Let's proceed to section 47, like the amendment to bylaws. So as the general rule, the board of directors or trustees by a majority vote thereof and the owners of at least a majority of the outstanding capital stock or at least a majority of the members of non-stock corporations at a regular or special meeting duly called for the purpose may amend or repeal any bylaws or adopt new bylaws. The exception is that the owners of 2/3 of the outstanding capital stock or 2/3 of the members in a non-stock corporation may delegate to the board of directors or trustees the power to amend or repeal any bylaws or adopt new bylaws. We need to take note that any power delegated to the board of directors or trustees to amend or repeal any bylaws or adopt new bylaws shall be considered as revoked whenever stockholders owning or representing a majority of the outstanding capital stock or a majority of the members in non-stock corporations shall so vote at a regular or special meeting. We also need to take note that the amended or new bylaws shall only be effective upon the issuance by the SEC of a certification that the same in accordance with the revised corporation code and other relevant laws.
So, what are the binding effects of the bylaw? So, basically, as to directors or trustees, officers, and stockholders or members, they are bound and must comply because they are presumed to know the provisions of the bylaws. Well, as to third persons, they are not bound unless they have knowledge of the bylaws.
So, karon nato sa section 48. As in, na-memorize yun din ako siya ng article. Ha? Section 48, kinds of meetings. Meetings of directors, trustees, stockholders, or members may be... Dili, di ay ko comment. Meetings, section 48, kinds of meetings. Meetings of directors, trustees, stockholders, or members in regular or special.
So now let's move on to section 48, kind of meetings. So yeah, generally stockholders or members of meetings are called for the purpose of electing directors or trustees and transacting some other business calling for or requiring the action or consent of the shareholders or members, such as the amendment of the articles of incorporation and bylaws, sale or disposition of all or substantially all corporate assets, consolidation and merger and the like, or any other business that may properly come before the meeting. In the absence of an express charter or statutory provision to the contrary, the general rule is that every member of a non-stock corporation and every legal owner of shares in a stock corporation has a right to be present and to vote in all corporate meetings. Conversely, those who are not stockholders or members have no right to vote. Voting may be expressed personally or through proxies who vote in their representative capacities. Generally, the right to be present and to vote in a meeting is determined by the time in which the meeting is held. So, this is part of the Title 6 of the Revised Corporation Code, which is meeting. So, under Section 48, it's the kind of meeting. So, basically, there are two kinds of meetings for directors, trustees, stockholders, and members, which are the regular or special. Also, I'd like to add something about the Section 48. For regular meetings, this meeting of directors or trustees for regular meeting, usually it's monthly unless the bylaws provide otherwise. Anywhere in or outside the Philippines, unless the bylaws provide otherwise, and the notice stating that the date, time, and place of the meeting must be given to the directors or trustees at least 2 days prior to the scheduled meeting, unless a longer time is provided in the bylaws. A director or trustee may waive this requirement either expressly or impliedly. For special meetings, when any time upon the call of the president or as provided in the bylaws, where anywhere in or outside of the Philippines unless the bylaws provide otherwise, and the notice stating the date, time, and place of the meeting must be given to the directors or trustees at least 2 days prior to the scheduled meeting unless a longer time is provided in the bylaws. A director or trustee may waive this requirement either expressly or impliedly.
Yeah, who shall preside the meeting? Well, Section 53 can answer that. The chairman, or in his absence, the president shall preside at all meetings of the directors and trustees, as well as of the stockholders or members, unless the bylaws provide otherwise.
Now, we're going to talk about Section 53 with the question, who shall preside at the meeting? So, general rule, the chairman, or in his absence, the president shall preside at all meetings of the directors or trustees, as well as of the stockholders or members. Exception is that unless the bylaws provide otherwise.
Talk about right to vote of secured creditors and administrators. Section 54. In case a stockholder grants security interest in his or her shares in stock corporations, the stockholder grantor shall have the right to attend and vote at meetings of stockholders unless the secured creditor is expressly given by the stockholder grantor such right in writing which is recorded in the appropriate corporate books. Executors, administrators, receivers, and other legal representatives duly appointed by the court may attend and vote in behalf of the stockholders or members without need of any written proxy.
So now we are at Section 54, the right to vote of secured creditors and administrators. There is no transfer of ownership in case a stockholder grants security interest in his or her shares in stock corporations. Examples like contract of pledge and contract of mortgage. Thus, the general rule is that it is the pledger or mortgager who has the right to attend and vote at meetings of stockholders unless they authorize their pledgee or mortgagee. The authority must be put into writing and recorded in the appropriate corporate books.
Lastly, Section 55. Voting in case of joint ownership of stock. The consent of all the co-owners shall be necessary in voting shares of stock owned jointly by two or more persons, unless there is a written proxy signed by all the co-owners authorizing one or some of them or any other person to vote such share or shares, provided that when the shares are owned in and or capacity by the holders thereof, any one of the joint owners can vote said shares or appoint a proxy, therefore.
We are now on section 55, voting in case of joint ownership of stock. So as a general rule, in case of shares of stock owned jointly by two or more persons, in order to vote the same, the consent of all the co-owners shall be necessary. The exception is that there is a written proxy signed by all the co-owners, authorizing one or some of them or any other person to vote such share or shares, and the shares are owned in and or capacity by the holders thereof. Any one of the joint owners can vote said shares or appoint a proxy thereof.